All right, well, good afternoon, everybody. Thank you so much for joining us today for our session on registering your company, basics of corporate formation. Today, I would like to thank Mark Ehrman for teaching this session for us. Mark is a partner with Quarles and Brady law firm. He's a corporate services attorney with 20 plus years of legal experience. Mark has concentrated on representing companies and their owners and investors in domestic and international stock and asset acquisitions and divestitures, mergers and other corporate reorganizations, and public and private finances. In addition, Mark has worked with a number of startup and emerging companies and their investors by assisting them with forming their companies, completing agreements among founders and employees, protecting intellectual property, and securing angel and venture capital financing. So thank you so much, Mark. Before we begin, I would like to make a few announcements about today's session. So you probably already heard that today's session will be recorded and will be posted on our YouTube channel. So if you would like to go back and revisit some of the points, you can. Also, please submit your questions via the Q&A function. There's a Q&A function at the bottom of your screen, and Mark will be answering all of the questions at the end of the session. All right, thank you.
Well, good afternoon, everybody. As Alice said, I'm Mark Ehrman with Quarles and Brady. For those of you who don't know Quarles, we're a large national firm. We have over 500 attorneys. We're spread out over a number of offices. We have offices in the southeast part of the country, southwest, midwest, where our headquarters are, and then we have an office in the District of Columbia. So happy to speak to everybody. I wish I was doing this in person because speaking to a computer is not the same as being able to see everybody's face and get their reaction as to if I say something doesn't make sense or whatever. So bear with me. I'm going to cover kind of a corporate basics 101 for people that are interested in setting up their company. I'm going to cover really three main areas. The first being kind of selecting your entity and things to think about in that area. The second would be basic corporate agreements you'll have to think about as you're setting up your company. And then the third part, I'll get into some financing and investment documents if your company decides to take outside investors. As Ella mentioned, I'll take questions at the end. So whatever questions you have as I go through, if something doesn't make sense, please make a note of it and I'll try to address it later. So again, the first topic I want to cover is types of entities. And there's really, I put up on this slide kind of the three main entities that people use. There are others like partnerships and sole proprietorships. You don't really need an entity to set up a business. You can do a business in your personal name. The problem with that is then the debts and liabilities of the business are your own personal liabilities. So most people, when they decide to set up a company, form an entity. S corporations, I'll mention briefly, those are not as common when you're setting up a business entity because there's limitations on that. But I think there's really two questions you have to ask once you set up your company. One is, where do I want to organize the company? So every state has its own rules. They're very similar across in this area. And so most people select one of two jurisdictions. They either set up the company in their home state. So if you're in Maryland, you're setting up an entity under Maryland law. The default provision for a lot of people is Delaware law. And people ask, why Delaware? It's really historic. Delaware, years ago, the members of the bar of Delaware decided they wanted to be specialists in some areas. And so they set up a very good corporate law that's become the basis for the corporate laws of other states and became known as the entity where companies are incorporated. So you'll see that many public companies, probably a majority of public companies, are Delaware companies because the laws there are good, they're well established, and actually the justices there really understand the corporate law and can determine cases consistently. So once you pick a jurisdiction, then you have to file a document in this jurisdiction. So it's either an articles of incorporation or certificate of incorporation, and that triggers your entity being owned. You also actually have to get a tax ID number for the company. So that's basically like a social security number, but it's for an entity. And that establishes a separate taxpayer number for that entity. And then they can then you use and file documents under that name. When you set up an entity, something to keep in mind is you have to, every year you're going to have to file an annual report. And it's basically just a report saying you're still in existence. You'll have to give some information about officers and directors. And the reason the states do that is they want to make sure the company's still in existence. And frankly, it's a way to get a little revenue each year from people having to file an annual report. So let me talk a bit about C corporations. This is the most common form of entity people select. I would say the biggest downside people talk about when they mention C corporations is the two levels of taxation. What I mean by that is when the company makes money, the company itself pays an income tax. You probably have heard during the campaign, corporate income tax has been one of the subjects the candidates have talked about. President Trump's in the administration lowered corporate income tax rates, and Vice President Biden has talked about scaling back some of those cuts. So that's become an issue in the campaign. But the corporation pays tax on its income, and then when the corporation distributes money to the shareholders pay tax also. That's why you have a two level of taxation. It is a form that's preferred by I would say most professional investors. If you're deciding to get investment from a fund, any angel fund or private equity group, they're going to likely want you to be a C corporation. Most of those entities don't like LLCs because they don't actually want the direct tax pass through. So as I tell people when they ask me about the types of entities, I wouldn't worry as much about the two levels of taxation because you really need to determine whether, and what type of entity you might want your company to end up being when you decide which way to incorporate. I'll mention S corporations briefly. The reason those aren't used very commonly for businesses that are going to get outside investors is because there's limits on who the shareholders can be. You can't have entities as shareholders for the most part. You also can't have foreign owners, and there's a limit on the number of shareholders you can have. It does have the pass-through taxation, meaning that there's no corporate tax paid. The tax is passed directly to the individual owners, and that's similar to LLCs, which is the other, I would say, second most common entity that people select when they're setting up a company. The LLC avoids the two levels of tax because the company itself does not pay tax. The tax is paid when it's distributed to the individual owners. Because the LLC laws are not as, they haven't been around as long as corporations, I would say there's a little bit more flexibility built into LLCs because there's the laws gives you a little bit more opportunity to move distributions around into the operating agreement in a way that's different than you can under the C corporation. It is somewhat popular for angel funded companies. Now let me maybe take a step back here and talk briefly about financing of companies. The way we really see companies typically financed is the company's set up. Sometimes it will get grants, and I'll talk about that in a little while. But oftentimes it gets money from what we call friends and family, and that's exactly what it sounds like. People that know the founders that are interested in investing some in the company to get it started. Then when the company needs more money, it typically goes out to angels. And angels are really high net worth individuals or groups of individuals that decide that they want to pool their money together and invest into a company. Most angel groups are just groups, meaning that they're not funds. They just do it on a deal by deal basis. And each deal they can decide how much they want to put in. Then when you get more financing down the road, you oftentimes go to venture funds or private equity funds. And those are actual funds, meaning that people have invested into the fund. The fund is managed by a professional investor, and they have funds available to invest however the manager wants, as opposed to kind of doing more of a pass the hat arrangement, which you have for angels. I mentioned LLCs are often used for angel funded companies. Angels don't mind the direct pass through tax treatment. What happens is they get what's known as a K1, which is your share of income off of that company, and then their K1s go on their personal income tax return, and they pay the taxes based upon that. If you set up an LLC, you can convert to a C corporation later. I mentioned if you get professional investors or funds that are investors, it's not that hard to convert to a C corporation. it's much more difficult to go back the other way to convert from an LLC to from a C corporation to an LLC. So when people ask me kind of what my reaction is as to which way they should go, I kind of answer that question with a question is, where do you think your money's coming from? If you're likely getting, professional investors, meaning funds as investors, then you're likely going to end up as a C corporation anyway, and you may as well start as a C corporation from the beginning. If you think your funding is going to be mostly from individuals, angels, maybe an LLC is the best route to go. So let me turn now to kind of once you get the company set up, what sort of documents we work with clients on establishing. And I think they fall within two categories. They're what I call governing documents and then sort of operation documents. So with the governing documents, I put up on this slide kind of, the hierarchy of things you have to think about. First of all, as I mentioned, every state has its own corporate law. So layered on top of all the documents you have for your company is you have to understand what the law is of that state. And the state's laws are similar, but not exactly identical. And each state will have slightly different laws as to how a company can operate its business. That's kind of the overlying principles that apply. Then you have what's called your articles or certificate of incorporation. That's what I mentioned earlier, that you file with the state to get your company set up. And that document is usually fairly straightforward initially. It's got the name of the company. It's got a purpose associated with it. Most times you just say it's engaged, the company can be engaged in any lawful business purpose. And then you have to designate a registered agent, because under each state law, there has to be some either company or a person who's designated as an official recipient of notice. There's a lot of companies that do that sort of around the country. And so for a fee, you can use one of those companies like CT Corporation or somebody else. And then you also create some stock under that articles. And typically you have one class of stock, it's called common stock. And so that's the article, that's a document filed with the state. And that can only be changed by another filing with the state. The next level of governing is the equity agreement. And that's an agreement, either shareholder agreement if it's a corporation, or an operating agreement if it's an LLC. And I'll talk about that in a minute. But we have some clients come to us and say, well, I just want to get the company set up. I don't really need an agreement among the owners. And our response to that is, and they say, well, because we're friends, we're colleagues, we'll just work it out. The agreement is really designed to be a template that if you can't work something out, if there's disagreements, you have a written framework as to what your understanding is going into the relationship. In the absence of that agreement, we found that you end up spending time and money trying to figure out what happens if someone no longer wants to be involved with the company. And then the next level, which will be the third part of my talk, is kind of the investment and financing documents. Those are all, those come in when you decide to get investors. Now, some of the investment stuff can be put in the equity agreement, but sometimes they have separate agreements, which I'll touch on in a minute. So let me talk about this equity agreement. That's probably the first agreement we use, what we start with when we're talking to clients. It's important because it does a number of things. The first thing it does is it defines what everybody's contributing to the company. When you think about it, if you have more than one owner, you have to say who's going to contribute what. It could be cash, it could be services, it could be property. The equity agreement spells out what everybody's contributing and what their percentage ownership is up front. And as you get new investors in or new shareholders in, that ownership structure, that ownership percentage can change. But it's important in the equity agreement to establish what everybody owns up front and how it's divvied up. The next thing it does is it prevents transfer outside the original shareholder group. So when you think about it, if you're going in business with a couple of people, you don't necessarily want one of them to say, I'm done, I'm going to transfer this to an unrelated third party, because you want to stay in business with the people that you're in business with. And if one of them wants to leave or wants out, then you need to establish what happens in that scenario. So what the equity agreement does is it does a couple of things. It says, first of all, you generally can't transfer to third parties other than some allowed estate planning transfers. You have to go through a right of first refusal procedure. And I'll spend a little more time on that in a few minutes, but it basically prevents the stock or the equity from being transferred outside the original shareholder group. It also could have some termination provisions where if someone who's working with the company wants to leave, then you have the ability to buy that person back either at a set formula price or maybe some sort of flat fee or whatever, but it allows you to work with your existing group and at least understand the possibility that the same group of people that start the company may not be there throughout the life cycle of the company. It also puts provisions in place as to how the company's operated. The way companies typically work is you have the equity owners and they elect a board of directors or a board of managers. And then the board of managers kind of have general authority to make material decisions. Then they typically appoint officers or managers to run the day-to-day business. But what the equity agreement says is it could put limits on what the board can do. It could also say certain material things have to be taken up at the equity holders level. And it might be either a majority or it could be a higher majority of equity holders that have to approve something. So examples of that would be, if you're going to sell the company or if you're going to do a liquidation or some form of financing, that might require equity holder approval, and it might require more than a majority of equity holders. And I'd say the last thing the equity agreement does is it provides some scenarios as to how the company will be liquidated. That could be through a sale, could just be through a liquidation of assets, but you need to contemplate sort of the entire life cycle of the entity when you get that set up. So we probably spend the most amount of time with our clients on working through the equity agreement. We have forms of these, but there's always some interesting scenarios that people put in front of us that we try to address through that agreement. The next sort of category of documents we work with clients on, I call operation documents. I put up on the screen what those are. You have non-disclosure agreements, those are NDAs, IP agreements, investment documents, and employment and consulting agreements. And so I'll cover the investments in the third part of my talk, but let me talk about NDAs briefly here. NDAs are important for companies, particularly if you have technology, either protected technology or non-protected from a patent perspective. And the key on NDAs, I think, is that you need to make sure they're limited in scope and limited in time, because a lot of jurisdictions like Wisconsin, where I practice, courts will not write their own interpretation on an agreement. If it's not enforceable because it's too broad, they just throw the entire agreement out. So where you might think you have a non-disclosure agreement in place, if it's too broad, it gets thrown out. And so when I say limited scope, what I mean is it needs to really cover stuff that is legitimately confidential, not sort of any information that's provided from one company to another. I've had clients that have told me, our price list is very secretive, it's confidential information. And then you go on their website and they post the price list on the website. So obviously that's not confidential information if it's generally available to the public. So we want to make sure that it's limited in scope and also limited in time. You don't want to have an NDA that goes beyond a year or two after the information is disclosed, because then you run the risk that it may not be enforceable. We draft NDAs as either, let me step back for a minute first and say there's one exception to that time issue, and that is for trade secrets. Trade secrets are a term of art, and what it is something that the owner takes reasonable steps to protect and keep secret, and it's also something that derives independent economic value from not being disclosed to someone that could get economic value from it. The classic example of that is the formula for Coke. Coke never trademarked that, never trademarked or patented it. They kept it as a trade secret. It was only known by one or two people in the company, and they kept it under lock and key. So I mentioned NDAs. There's really two different ways we draft those. One is kind of a form that the companies can use, a one-way form where the company is giving information to a third party, and that's confidential. We also do two-way agreements where it's contemplated that both sides are exchanging information to the other, and that each side agrees to keep what it receives confidential from the other. Next area we work on is IP agreements, and this is particularly germane when we're working with folks like universities, because part of my practice is working with universities as clients, like University of Maryland, and working with them on licensing and equity agreements when they're doing startups. I also work with startups getting the licenses from universities and other third parties, and then we will also work with investors who are investing in those companies. So when you're talking about licenses, a lot of you probably know the basis of this, but you need to determine, the term of the license. Is it perpetual? Is there a term on it? Are there milestones that have to be met for the license to stay in place? What sort of field of use? Is it broad? Is it for research only? Are there limited applications for the license? And then what's the compensation structure? Oftentimes we see some upfront payment, and then we see a royalty stream going forward, and that varies depending upon the license. And then in some cases, and actually this is becoming more popular, universities are taking equity as part of their upfront fee. So they'll get a portion of the company in exchange for the license. And then they become a shareholder like everybody else. So we work a lot in licenses because that's very important. And investors, if you get investors down the road, will be concerned that you have your license and IP solidified. The next thing we do with clients is work on assignment of inventions clauses. And this is really for the people that are working for the company, both employees and consultants. You want to make sure that a lot of people that are hired generally have a large, broad background and a lot of know-how, and you want to make sure that the items they're working on while they're getting paid for by the company are actually company property. So we do forms of assignment of inventions where the individuals that are working on those projects agree to assign their inventions over to the company. Because as I mentioned, investors in the company down the road will want to make sure that that your IP is protected. I mentioned investment documents. I'll cover these in a few minutes. These are the typical investment agreements that you'll see investors want to have. Voting agreements, right of first refusal, investor rights agreement. Some of these provisions can be put in an equity agreement, but oftentimes when you have outside investors coming in, they want separate documents on this. Employment consulting agreements is probably the next operation area we work with clients. It's not necessary to have employment agreements with people. Most state laws are pretty clear as to what happens when you have an employee arrangement. It's a little bit less clear on consulting arrangements. So we recommend, certainly when you're hiring a consultant, that you put the terms in writing. You want to define, I think, the duties that the person has, what sort of compensation they're getting, how that's paid, and really what other activities they can engage in while they're working for you. States and the government have become more restrictive on consulting arrangements, and they've taken the position that if you have full-time consultants who are doing nothing but working for your company, and they don't have any other projects, and they don't really have a consulting business, that they really should be employees under the law, and they'll deem them employees. So one thing to keep in mind is to make sure that your consultants really are consultants, your employees are employees. We also work a lot on equity incentives for clients. What those are either option agreements or restricted stock plans where individuals who work with the company, they could be employees, consultants, board members, they receive a piece of equity of the company in exchange for their services. Normally those have a vesting schedule, meaning they don't get it all up front, they get out over time, because you want those people to continue to be involved with the company for a period of time. And so that's a common set of documents we put in place. Our experience has been that probably between, let's say, 10 and 22% of the equity of a startup is held in reserve for these equity incentive policies, because you want to give people incentives to stay involved with the company and to join the company, because the startups typically don't have as much ability to pay upfront cash payments, so they try to offset that with some equity that they're giving people when they join the company. And the last thing in the employment area is employment policies. And we have a pretty straightforward handbook that we use for companies. I think it's important to have policies in place, at least general policies, because what happens is those employment policies basically become like the contract between the employee and the employer. So things like how often, obviously what vacation policies you have, whether you have paid time off or sick leave, all that stuff is helpful to spell out in a policy. And like I said, so we typically do employment policies for clients and get them set up that way. Let me talk now kind of to financing and investment documents, sort of the third part of my talk. So we typically see companies get financed through three general ways, and they're up on this slide. First of all is grants, and I think a lot of people are familiar with grants. Those are grants from the government or private, foundations or private individuals that are non-dilutive, meaning that they're just cash provided to the company. They don't take any equity back in exchange for that cash payment. They're usually subject to some restrictions because they don't want you to use those grants typically for just general working capital. They want you to use them for specific purposes. But a lot of our clients get a lot of their initial funding after the friends and family round through grants. They're also debt. I mean, I think people know what debt is, borrowing money from a third party. That shows up as a balance sheet liability. Our experience with early stage companies is banks, traditional banks, aren't very anxious to lend money to startups because they want to have secured debt, and they can secure it either through a lien on the assets of the company or a personal guarantee from some of the founders or all of the founders. Providing a personal guarantee in some ways offset that limited liability I discussed earlier. I mean, if you're willing to, people do it, but I'd question whether that really makes sense. If the company can't support the debt on its own, should you really be guaranteeing it to the bank? So loans from banks, with maybe the one exception being Silicon Valley Bank, which has some early stage loan programs, it's not really a good option for startups. I will mention convertible debt in a minute, and that is used oftentimes. And then you have equity, and equity is probably the most common way as the company gets established that it raises funds going forward. So the use of convertible debt has increased over the last several years. And what convertible debt is that's debt that's issued by usually an individual or a set of individuals that they lend the money to the company and then they take a note back. And the reason it's called convertible, it's because it's convertible into sort of the next round of equity financing. It's typically unsecured, but it could be secured. And so let me give you an example. So let's say I have a company that's interested in raising $2 million because I've figured out that that's the money I need to get a project to a certain point. But I don't have investors that are interested in investing the full $2 million. Let's say I can come up with, from individuals and other sources, 500,000 of that capital. So instead of just issuing the equity for 500,000, what I could do is say, I'll sell you convertible notes for $500,000. And then when I'm able to raise the rest of the $2 million, then I sell the $2 million of stock, and included in the $2 million, the notes are converted into that stock. Now, in order to incentivize, someone to do that investment, because that's, it's a risky investment, they're coming on board at early stage in the company, you typically give them what's known as a discount. So you'll say that instead of converting the debt, let's say at $1 a share, you effectively converted at 80 cents a share or 75 cents a share. That would be a 20 or a 25% discount. And what that does is that gives the people that have the convertible notes more of the equity round than they otherwise would have had they just invested at the time. So that's a common way to finance companies. And the benefit of that, there's a couple of benefits. One is it kind of defers the discussion on what the company is worth at the time of the investment, because whenever you're issuing equity, you really have to come up with a value of the company. There's what's called pre-money value, which is the value before the money comes in, and then post-money value, which is the value after you've gotten the equity. And it's very hard to value early stage companies, because there's not a lot of comparables in the market. So people have a hard time, I think, coming up with a pre-money valuation. So one way they can do with notes is they can sort of punt that decision till they raise the rest of the funds. And then when the other investors come in with the rest of the $2 million in my example, they've then established the value of the company, and the debt just converts at that value. So now let me turn to equity. When you sell equity, and there's really two different sets of rights that go with equity holders, and that could be angel investors or venture capital firms or private equity groups that I mentioned earlier. One are what I would call structural rights, which are found in the certificate of incorporation, and the other are contractual rights, which are found in other documents. So let me cover the certificate first. So I mentioned earlier that when you set up a company, you usually have one class of stock, common stock. When you get outside investors, they will oftentimes ask for preferred stock. And that means kind of what it means. They become preferred shareholders over the common shareholders. And they're preferred in several respects. But what happens is the company will amend its certificate of incorporation because you have to create that new class of preferred stock. And as you get multiple rounds of investors in, sometimes they will have different series of preferred stock. Usually you start with Series A, then you go to B, C, D, E, et cetera. Companies like Facebook, I think they might have been up Series G or Series H before they went public. So it's very common that these early stage companies will be financed with several rounds of investors. And one general rule of thumb that I like to keep in mind is when you talk about these preferences, it's kind of like a LIFO concept for accounting. The last money in is the first money out. So as you get more and more rounds of financing, typically the latest round comes out first, and then the second latest, and on to that way. And so what the certificate covers is how the preferences work. One way is voting. Most preferred stock is voting, and it's typically voting just on a one-to-one basis. So in other words, you get the same number of votes as the number of shares you own. You could also do voting on an as converted basis. So preferred stock is typically convertible into common, and sometimes it's convertible at 1-to-1, but sometimes that ratio changes. So you can structure the vote so that you vote as though you had the common shares in the cap table. It also specifies whether all the classes vote together. Under general corporate law, most items just require a simple majority of the shareholders voting together as one class. Now, there are a couple of exceptions to that, but that's the general rule. But what the certificate does when you have investors is it establishes class voting rights. So it's not uncommon that you would say certain material matters like selling the company, changing the line of business, that requires the separate vote of each class of preferred stock voting separately. And there are some other things that could require common votes of all the preferred voting as one class. So those voting rights are established under the certificate. The next thing it does is it provides for dividends. Most preferred stock accrues dividends. Now, early stage companies don't typically pay cash dividends because they don't have the money. But what happens is the dividends accrue. And then when the company is sold, the preferred shareholders get the accrued dividends paid at the same time of the sale. And there's really two different ways that can happen. One's called participating preferred, and the other's called non-participating preferred. So in participating preferred, let's say an investor invested $1 million in preferred stock at an 8% dividend. That means that each year that shareholder earns an extra $80,000 on its preference. So when the company is sold, that $1 million plus all the accrued dividends, $80,000 per year for however many years it's been in place, that will get paid to the shareholder off the top. And then you will do a calculation, then you basically convert those shares into common, and then that shareholder would get his or her pro rata share of the rest of what's left paid to all the common holders. That's participating. So that when you think about that, it's kind of a sort of two kicks at the apple because they're getting both their preference and their conversion percentage. The other way is non-participating. And in that scenario, the investor who owns the preferred stock has the option of either taking the $1 million plus dividends or converting into common, but you don't get both. And obviously the decision is based upon how much the stock is worth and what the value of the company is at that time. Then the last thing you talk about is conversion. I mentioned that briefly. So preferred stock is usually convertible, and it starts out converting at 1-to-1. But if the company ends up doing what's called a down round, meaning that it issues subsequent stock at a lower valuation than that preferred stock was issued at, there's a calculation, and then the conversion rate changes. So that preferred stock, instead of being convertible 1 common to 1 preferred, is convertible possibly 1.5 common to 1 preferred. So they end up with a larger ownership percentage of the company. So that's kind of the structural rights of investors. Let me talk kind of for my remaining time on this section on the contractual rights the investors have. And there's really 3 main agreements you'll see when you're working with companies. And these are all, they're all agreements that have been issued by the National Venture Capital Association. That's a national organization that works with venture capital firms. And they've developed standard set of documents. And these are all online. They're free. You can download them. They're long. They're relatively complicated, but people that work in this area, like myself, you like it when people use these agreements because you understand what they say. You've read them several times, and so they're standard. And the first one of those is an investor rights agreement. So in addition to the protection of the certificate, investors in preferred stock want to have certain other rights. And one of them is registration rights. I think a lot of people assume if a company will go public, that all of its stock becomes publicly trading. That's not true. What becomes publicly tradable and registered is the stock that is issued in the public offering, not all the stock. So in order to allow investors to sell some of their stock in the public offering, they're granted what's known as piggyback rights, which means that they can say to the underwriters of the offering, I want you to sell some of my shares in the offering in addition to the company's shares. And there's usually limits on that as to how much of the offering that can be, but those are rights that are granted in the investor rights agreement. And there's a relatively complicated set of registration procedures that go with that. It goes on for probably 8 or 9 pages of what the company has to do in that situation. The second main right to provide in this agreement is information rights. Under the law, an equity holder has limited rights to information from the company. Generally, under most state laws, you only have the right to get annual financial statements and like a list of shareholders. And that's it. So investors, obviously, they're investing a lot of money. They want to have more rights, more information. And so you'll see these provisions that say they get not only annual financial statements, but they get quarterly statements, monthly statements, plans, projections. They might even get all the information that's provided to board members in the board meetings. So the investor rights agreement spells out what type of information is provided under to those investors. And there might be different investors. If you've invested more money, you might have right to more information than if you invested a lesser amount of money. The second agreement you'll see is a voting agreement. So I mentioned that the certificate covers kind of general voting and how it works, but a voting agreement is an agreement by which the shareholders say, look, we want to actually agree on how we're going to vote on certain matters. So the first is board composition. I mentioned that equity holders elect the board, who then elect the officers. So these voting agreements typically spell out how many directors are going to have, which class of stock, if any, gets to elect each director, and then it provides potentially for procedures to remove those. And usually the way it works is if I'm a preferred shareholder and I get the right to designate one director, and my director resigns, my designee resigns, and I get a right to replace to elect a second director. And in the voting agreement, all the equity holders agree to vote their shares for that class of directors. I should say that most companies we work with have you have a board that's somewhere between 3 and 7 people. I think more than that gets a little bit cumbersome. You do want to have, I would think, more than 2. And I'd always try, if I could, to reserve at least one spot for someone, sort of an outside independent director, someone who's an industry expert and maybe doesn't have an investment in the company, but is really designed to kind of weigh maybe the differences between the founders and the investors on certain things. The other thing the voting agreement does, in addition to voting on the board, is it decides how you're going to vote on other material matters. So I mentioned earlier things like incurring debt, buying or selling real estate, selling the company, liquidating the company. Those are major matters that oftentimes you reserve to the shareholders for approval. And the voting agreement spells out what sort of approval is required. And usually it's more than a majority. It's some sort of supermajority, meaning somewhere between 50% and 100% of the shareholders have to approve that particular item or list of items. And our experience on that is you want to have that threshold set at a level where no one shareholder or small group of shareholders can block something, but also you want to have enough buy-in from your shareholders that you can get it approved. Or if they don't approve it, then you'll move on to a different topic. The last agreement I want to mention is the right of first refusal and close sale agreement. And this really, it's similar to what's in the equity agreement, but it's usually broken out as a separate agreement once you get investors in. And it allows the company to the existing shareholders, once the investors come in, to maintain their kind of ownership group. So if one of those shareholders wants to sell its equity, and this is particularly important when you have investors in there because investors are more likely to want to sell their equity than founders, they have to give notice to the company, and the company then has the right to buy that stock back at the offered, subject to the offer. If the company doesn't accept that offer, then the other shareholders typically have the right to ante up their pro rata share to keep it within the shareholder group. And then sometimes you'll actually see sort of a third round that if all the stock is still not accepted, then you go back to the investors who have accepted under the first round, see if they're interested in buying more. But the idea behind that is that the existing group of investors stay as investors, and you don't have it sent to outsiders. The next thing the right of first refusal agreement does is it provides preemptive rights. What preemptive rights is the right to continue to invest in the company and maintain your pro rata ownership. So for example, if I own 5% of a company and the company is raising $1 million of financing, I would have if I have a preemptive right, I have the ability to invest $50,000 of the million to maintain my pro rata ownership. Now it requires me to write a check, and I basically invest on the same terms as the new investors coming in, but it gives me the right to maintain my pro rata share. Most investors who come into companies don't really like to give up any of the $1 million investment in my example, so they'll ask the existing shareholders to waive their rights. They say, we don't want to have all the shareholders exercise their rights, because if you do, then there's no money left for us to provide. So a condition to the closing typically of investments within outsiders is the waiver of preemptive rights. And the last thing it does is have co-sale rights. And co-sale rights are really one of two categories: come along rights and bring along rights. A come along right is the ability I have as a 5% shareholder in my example to go along and to participate in the sale of the company. And a bring along right is the right that the company has to make me participate in that transaction. Because if the majority of the shareholders decide they want to sell the company, you don't want to have any stray shareholders saying, I don't want to participate, or I'm not going to sign things. So you do these come along and bring along rights to make sure that you can sell 100% of the company to a third party. And there's typically some procedures put around that say that everybody's got to be treated the same in each class. You can't favor one shareholder over another and things like that. So that's the right of first refusal and co-sale agreement. So I've covered kind of what I intended to cover. I'm happy to take questions. I've just probably given you like a half a semester law school class in 45 minutes. So I understand you may have some questions, or if you want to follow up with me later, please do so. So with that, I'll open it up.
Okay, we have one question from Giovanni. After incorporating an entity, is it mandatory to open a business bank account? Is there something in particular that an early stage LLC entity should pay attention to when choosing banking services?
Yeah, good question. So it isn't a requirement to open a bank account, but most people do, and I'll tell you why. First of all, generally you need to get that tax ID number that I mentioned to get the bank account open, because when you go to a bank to open an account under a company's name, they're going to ask for your tax ID number. But one of the main tenets of having a separate company, the limited liability I mentioned, in order to have limited liability through an entity, meaning you're not personally liable for the company's debts, you have to run your business like a separate entity. And one of the things that they look at there is, do you have separate books? Do you have a separate bank account? Do you have potentially a separate website, email address, things like that? So if you set up a company, but basically run everything through your personal financial statement or financial account or bank account, you're a little bit closer to the line of having someone come back and say, it's really not a separate business, and you're liable for the company's debts. So most people want to preserve that formality by having a bank account opened and do it that way. As far as which bank to choose, I would interview a couple of different banks. I would encourage people to select banks that have worked with startups before, because not all banks work well with startups. There are some big banks that, unless you're a big corporation or an individual, startups don't mean a lot to them. So there are usually every significant size town has at least one or two banks that are used to dealing with smaller businesses, maybe not startups, but I would say closely held businesses. And they would be the ones that can probably provide you some good service. They might even have some materials that they could, give to you, or maybe some other services they could provide you free of charge as part of their package. The other thing I would say is also keep in mind that eventually the company might be big enough that you can get a traditional bank loan. So if you end up growing and buying some assets, having some inventory, or even buying real estate, eventually you'll be able to get a more traditional bank loan. So you also want to understand is the bank going to be easy to work with if you grow to a certain stage and can secure more traditional financing.
Thank you, Mark. Presently, there's no other questions, so please feel free to type in your question. If you'd like to speak, you can raise your hand and I can unmute you and you're able to ask your question there as well. While we are awaiting questions, I would like to introduce a poll with a few questions and would love to get your opinion as to how we are doing with our workshop so we can improve if necessary. Okay, we have a question from Sandra. I would like to know more about the tax implications of an LLC versus a C Corp for the founder versus investor.
For founder versus investor?
Correct.
Right, okay. So, yeah, so when as a founder, if you only have founders or individuals involved, the LLC will allow you to only pay one level of tax. So in other words, if the company makes money, let's say the company makes $200,000 and you've got of income and you've got 4 shareholders and they each own 25%, that year each shareholder would be allocated $50,000 of income from the company. That income would then go on their personal tax return and they would pay tax at whatever rate they pay. It would just be like they earned an extra $50,000 of income from the company. Now that would be the case really, even if the company didn't distribute the money to them. So in other words, the company could earn $200,000 of income, but not distribute it out to the shareholders. So one of the things the equity agreement that I mentioned typically does is say to people, look, if the company earns money and you have a tax liability, the company agrees to distribute you enough, at least for you to pay your tax. So you don't have to go out of pocket. Because in my example, if you have $50,000 of income, and so you get taxed on that, but the company's not paying, is holding on to that money, then you've got to come up with the tax payment from other sources of funds. Now, contrast that with a C corporation, where in that same example, if the C corporation earned $200,000, it would pay income at the corporate tax rate, and so let's say that's low 20s. And then when it distributed money out to the individuals, they would have a second layer of tax. So from an individual founder's perspective, the LLC is more tax efficient, meaning you're going to end up paying a little bit less tax. But as I mentioned in the first part, once you get outside investors, they don't like LLCs typically. Well, angel investors don't mind them, but funds don't don't like that. So they will require you to change to a C corporation. So oftentimes we see companies starting out as LLCs because it's, they think there's going to be some tax efficiency there. And then if they decide to get outside investors, then they convert over to a C corporation when they get the outside investments. If you don't, I like to say though, don't let the tax tail wag the corporate dog, meaning you should set up your company the way what makes most sense for the operations. The tax is one issue, but there's a lot of other issues associated with that. So if you really think, you're going to have outside investors, and actually a lot of these early stage companies don't really have income for a long time, or they might build up losses, like net operating losses, meaning that they can shelter income down the road for a number of years until they use up the NOLs, then it might make sense just to start out as a C corporation.
Thank you, Mark.
I should mention, we're waiting for other questions, that we have what I call a startup package for individuals that are interested in working with us. As a law firm, people are sometimes scared off by our rates. We have a kind of a standard set of services we'll provide to early stage companies at a fixed fee, and we'll try to defer some of that until a financing event. And that's, we have something, I think it's on our website, but we can get that to you if anybody's interested. And that's just really a template. We can customize that based upon, facts and circumstances. But more than happy to talk to people if they're interested in discussing any of this stuff. I think starting a company is kind of a daunting task, and people are a little sometimes scared off by it.
Okay, I'd like to just share the results for the poll briefly. For those who participated, I would like to say thank you. And we do.
Jeff raised his hand. I can't tell what his question is, or maybe.
Sure. Thank you. Okay, Jeff, you are allowed to speak.
Okay, good afternoon, and thank you for a fantastic presentation. Really learned a lot and appreciate it. My question is, can you hear me pretty well?
Yeah, I can hear you fine.
Can you? Okay. I was saying my question is, are there any major differences, and if so, what are they, if you plan to be doing most of your business domestically as opposed to a company that would do a lot of business also internationally?
Yeah, that's a great question, and that's actually a different issue than what I talked about today. I don't know that there's really any difference between C corporations or LLCs as it relates to foreign operations. When you get into that, we typically have a number of people we've worked with that kind of have to determine how the various tax treaties and tax structures work. So, for example, if you do a lot of work, let's say in India, and your income is over there, how do you get it back to the U.S.? And once you get it back to the U.S., then it's typically treated the same way I mentioned, either as a pass-through or not. But there are some issues on getting it back into the U.S., and there might be taxes on that as well. So that's kind of we could give one of my colleagues could give a whole nother talk on that, because we have international tax. Like certain states.
Okay, well, thank you.
Europe and things like that. So that's a great question, and you have to figure out, and there's different ways you can structure agreements so that, for example, maybe you can bypass having to actually receive the money, in another country. You get it sent here, and it's paid here, and it's revenues earned here, and things like that. So.
Thanks, Mark. We have another question.
Okay, well, thank you once again.
Sure.
I'm sorry about that. We have another question from Safura. Regarding the place of company, if I know my location will be changed in a couple of years, maybe several times, which state should I choose? States should I choose?
Yeah, I guess I would choose, in that case, I would probably choose Delaware because it's the most common state. I should step back and say for a minute, if you have you could, you have the state of organization is one thing, a state of incorporation, but then if you're doing business in a state, and different states have different meanings of what doing business in the state means. But if you're doing business in other states, those states typically require you to be qualified as a foreign corporation in that state. And typical examples of doing business are if you have a physical facility, not maybe just one person working out of his or her home, but if you actually have like leased office space, you're probably doing business in that state. So to give you an example, Quarles and Brady, we're set up as a Wisconsin company, but because we have Florida offices and Arizona offices and Indianapolis offices, we have to be qualified as a foreign entity in each of those jurisdictions. And the reason they do that is because they want to be able to, well, one, extract a fee from you every year, but also they want to have you located in that state in case someone has a dispute with you and wants to, sue you or get a hold of you in that state. So if you're going to have a company that has multiple locations where you actually have physical locations, probably selecting Delaware is the way to go, and then you might have to qualify in those other states where you have locations. I would say typically having just a salesperson in a state is normally not a sufficient nexus to have to qualify there. The other thing the qualification does is they can collect income tax from you in that state as well. So.
Another question, can you highlight some best practices from a legal perspective for a single member LLC for a service-based business?
Sure. Yeah, so a service-based business, I guess I kind of covered a little bit. In order to have it as a separate business and really have the separate entity observed, I would first of all have a separate bank account. I would probably have a separate email address, maybe its own website, stationery, and actually kind of run it as a separate entity as much as possible. You don't have to have a separate facility, but you should really try to preserve some of the corporate formalities that will allow you to be deemed a separate entity. So we see people that do that all the time. They set up, let's say, a consulting business or a service business, and they have, they might have a separate mailing address. Maybe it's just a post office box, but they'll have a website, different materials, kind of create a different look and feel from your personal stuff. And I think having a separate bank account, maintaining separate financial statements, even if they're basic financial statements, is all helpful.
Another question, if an LLC has more expenses than income, can the founders claim the LLC's expenses to lower their own individual tax?
Yeah, generally, yes. In other words, you'll have some, you'll have some, so that the income and loss should both, in most cases, both translate, to your personal return. So, because it's a pass-through, it's considered a non-tax paying entity. So whatever tax attributes the company has get passed through to the individual, generally speaking.
Thank you. And our last question before our time is up. Should the purpose of the company be solid, or I can start with selling company and later, for an example, make it completely research-based company?
Well, when you set up the company, most people, for the purpose, just simply put in there, the company's organized for any lawful purpose that companies can be organized under the laws of that state. You don't necessarily have to specify the purpose when you set up the company. As far as practically switching, I don't think there's any issue there. We see companies all the time that pivot from, they might be a products-based company, they end up being completely service-based because they find out their customers really don't necessarily need their products, but they like the services they provide. And you can do that without really changing your organizational documents, because as long as you're set up with a very broad purpose, it won't require you to change any of your organizational documents.
Thank you, Mark. At this time, I'd like to thank our speaker, Mark, today for presenting, for sharing all this informative information to each and every one of us. I thank you all for attending our session today. And I have learned a lot. Hope you did as well. And thank you again, Mark, for presenting and for sharing with us today.
Well, thank you all for listening. I'm sorry I didn't get a chance to meet you in person, but I look forward to meeting you at some point down the road. Thanks.
Bye.
Thank you so much, Mark, and thank you, Wendy, as well.
Thanks, Ella. Bye.
Bye.